H1B labor condition application, an overview. The labor condition application, or LCA, is a prerequisite to H1B approval. The LCA, Department of Labor Form 9035, contains basic information about the proposed H1B employer or employment, such as the rate of pay, the period of employment, and the work location. It also contains 4 standard attestations or promises that the employer must make. The employer must also document compliance with the LCA requirements in a public access file. Filing of the LCA application. An H1B petitioning employer must file the H1B labor condition application on Form ETA 9035 electronically through the DOL's new ICERT web portal, found at icert.doleta.gov. While the DOL preferred method of submission is through ICERT, employers can file a paper copy. However, they must receive advance permission from the administrator of the Office of Foreign Labor Certification before doing so. At the present time, e-filing through ICERT portal is taking about 7 days. The DOL is hoping to shorten this time frame as they work out the bugs in this new electronic filing system. A single labor condition application for H1B may be filed for multiple positions. Each LCA is limited to 1 occupation with specified job duties. If the employer places an H1B non-immigrant outside the areas of employment listed on the H1B labor condition application, the employer must consider whether to file a new LCA and an amended H1 petition with the USCIS. The LCA must be certified by the DOL and submitted with the Form I-129 before the H1B petition may be approved by USCIS. Let's take a quick look at a case scenario. Company A wishes to hire Jan, who is currently working on an H1B visa for Company B. They extend an offer to Jan, who accepts it and returns the signed offer letter to Company A. Company A knows that Jan can begin work as soon as a new I-129 has been filed for her, so they complete and submit the LCA through the new ICERT portal. Because they want Jan to start as soon as possible, they submit the I-129 without waiting for the LCA. It's currently taken DOL 7 days to certify and return the LCA. Jan starts work for Company A the day after the I-129 is filed. Will she run into problems in this situation? The answer is yes. A Form I-129 for H1B must include a certified LCA to be complete. The USCIS will either reject the petition or request the LCA through an RFE. In either case, Jan has entered into unauthorized employment because the I-129 was not properly filed. The USCIS may approve the new H1B status, but will not approve the change of employer. Jan will have to depart the U.S. and return using her old H1B visa and new approval notice, or she may have to obtain a new H1B visa before she can return. Let's look at the attestations made by the employer in the LCA. By signing and filing the H1B labor condition application, an employer makes 4 attestations or promises. The employer attests that it is paying and will continue to pay H1B employee wages, which are at least the actual wages paid to others with similar experience and qualifications for that specific job, or they are paying the prevailing wage for the occupation in the area of employment based on the best information available. It will provide working conditions for the H1B employer that will not adversely affect the working conditions of workers similarly employed in the area. Working conditions commonly refer to matters including hours, shifts, vacation periods, and fringe benefits. Third, there is no strike or labor dispute at the place of employment. And fourth, it has provided notice of this filing to the bargaining representative if there is one, or if there is no such bargaining representative, it has posted notice of filing in at least 2 conspicuous locations at the place of employment for a period of 10 business days. Let's look at the public disclosure or public access file. The employer must make available at its offices for public examination a copy of the LCA and necessary supporting documentation regarding the H1B worker and other similarly situated employees. Specifically, the employer must create and maintain a public access file to document compliance with each H1B case. The public access file must include a copy of the LCA with the employer's original signature and cover pages, documentation of the wage to be paid to the H1B employer, offer letter or other types of evidence, an explanation of the system used to set the actual wage, a copy of the prevailing wage determination from the Department of Labor or a description of survey or other source used, a copy of notice to the union, if applicable, or the postings. Must also include a summary of benefits plan offered to the H1B employee, showing that it is the same as that offered to similarly employed U.S. workers and H1B employees' elections, if any, and a copy of the certified LCA with signature of the H1B employee as proof he or she received a copy. The documentation regarding the adjustment of wages, i.e. if they are given an annual raise or cost of living increase. Where the employer undergoes a change of the corporate structure and does not choose to file amended petitions for each H1B it acquires, the public access file must also include a sworn statement from the new employer that it accepts all obligations under the LCAs filed by the predecessor employee and include a list of the affected LCAs. What happens when you want to withdraw the labor condition application? In order to limit any potential liability, the employer must withdraw a certified labor condition application for H1B if the H1B employee working under them terminates H1B. This may be done if no H1B employee is employed at the place of employment pursuant to the LCA and no investigation has been commenced regarding the particular application. If you have questions about what steps you should take in your particular situation, consult a VisaPro immigration attorney. We will be happy to guide you through this process.